Hello everybody, my name is CA Prithviraj Yadav and I am a qualified chartered accountant, and I've been teaching for CA students for past 2 years at both foundation and at intermediate level, and the subject which I take up is your corporate and other laws, which is paper number 2 at your CA intermediate level. Okay, right. So this is my brief introduction about me. Yeah, so let's get started without any further ado. Okay, one important thing is, before I actually start this subject, okay, I would first like to brush up on the basics of law, because most of the students who have come from direct entry would not have the basics regarding the law. So for that very reason, instead of directly starting with the subject, I would first brush up on the basics of law, then I will start with the actual syllabus, because the basics which I would be teaching you today are very much required in order to understand the entire subject which we are going to study in the coming days. Because if this is not clear, then every time when I teach something, I have to again explain you time and again. So to avoid that, I would just first give you a basic understanding about what is law, how the law is made, what are the different types of law, all sort of things which are not part of your syllabus, although very important for you in order to understand the entire syllabus. Okay, so with that intention and with the assumption that you are studying the law for the very first time, I would start with the basics, then move on to the actual part of the syllabus. Okay, that would be our ideal template. Okay, and one more thing before that also, I would first tell you what is the syllabus. Okay, so first let us discuss what is the syllabus, and then I will start with the basics. Okay, fine. Now the paper number 2, the subject is what your paper number 2, and the name of the subject is corporate and other laws. Now this paper number 2 is divided into 2 parts, as it's very clear. First part is called as corporate law. First part is called as excuse me, first part is called as corporate law, corporate law. And the second part is called as other laws. Just a second, there's some problem with the pen. Yeah. Okay. Corporate law, and the second is other laws. Okay, now what do you mean by corporate law, and what are the laws which will be studying in corporate law, and what are the laws which will be studying in other laws? Okay, when it comes to corporate law, the laws which will be studying is the law. Corporate law means any law. Corporate law means what? Any law which is applicable to body corporate. Any law, any kind of law which is applicable to what? Your body corporate. Such laws are called as corporate laws. As simple as that. Any law which is applicable to what? Your body corporate. Such laws are called as corporate laws. Now the question arises, what do you mean by body corporate? Okay, so before understanding what do you mean by what are the laws which are going to study in corporate laws, first you should understand the corporate law is applicable to whom. So the first question is simple, to whom the corporate law is applicable? The corporate law is applicable to all types of body corporates. So the second question that arises now is, what is a body corporate? Okay, now the word body corporate has been defined under section 2 clause 11 of the Companies Act 2013, and the definition of the body corporate says that body corporate means a company. Body corporate means a company which is defined under section 2 clause 20 of the Companies Act 2013. Body corporate also includes company which is incorporated outside India. First is any company which is incorporated in India. Second, any company which is incorporated outside India is also considered as a body corporate. Third one is any LLP which is incorporated in India, and fourth one is any LLP which is also might be even incorporated where outside India. All these four together are called as body corporate as per the definition which is given under section 2 clause 11 of the Companies Act 2013. Body corporate includes these four things. So this is called as inclusive definition. These are such definitions are called as inclusive definitions, where it will not tell you what is the meaning of the word, it will just tell you what are the things that are included in that particular word. So this is one such example of your inclusive definition. Okay, so body corporate includes four things. First one is company incorporated under Companies Act 2013, that is, in simple language we can say any company which is incorporated in India, that is your Indian company. Second is any company which is not incorporated in India but incorporated where? Outside India. So in simple terms we call it as foreign companies. Third one is LLP which is incorporated in India, and fourth one is LLP which is incorporated outside India. So these four are considered as what your body corporate as per the definition. Now let us understand what is the meaning of body corporate in the first place. Now we understood what are the things which are considered as body corporate, but now let us understand what is actually the meaning of body corporate. Okay, now if you want to consider yourself as a body corporate, then four conditions has to be fulfilled. Four conditions has to be fulfilled, then only you will be considered as what? A body corporate. Okay, the first condition is that it should be registered under some kind of law. It should be registered under any law. It may be any law, but the registration must be compulsory. What is the first condition? Registration. Registration is nothing but what? Your registration is mandatory under some kind of law. It may be any law, but registration is what? Mandatory. Second one is you have a separate legal entity. You have what? A separate legal entity. You have what? A separate legal entity. Then also you will be considered as what? Only then you will be considered as a body corporate. Point number 3 is you should have perpetual succession. You should have what? A perpetual succession. That is the third condition. First one is registration must be mandatory. Second one is you should have a separate legal entity, and third one is you should have a perpetual succession, and fourth one is you should be capable of suing other third party and being capable of what? You're sued by third person. Means you as a person have a right to sue third party, and third party has a right to sue you. Sue means to file a case. If all these four conditions are satisfied, then that particular organization or that particular body or that particular entity, we call that as a body corporate. What is the four condition? First, the registration must be mandatory. It should have a separate legal entity. It should have perpetual succession, and it is capable of suing other parties, and is also capable of being sued by the other parties. If these four conditions are satisfied, you will be called as a body corporate, and according to the definition, these four are considered as what? Your body corporate. But there's one entity called as cooperative society. Cooperative society. Cooperative society. Okay, just a second. Okay, so there's one entity called as cooperative society. Everyone must have heard the word, right? Cooperative society. Now let us check whether this is a body corporate or no. Okay, As per the conditions, what are the conditions? First, registration must be mandatory, it should have a separate legal entity, and it should have perpetual succession, and it should be capable of suing other parties. Okay, so now cooperative society, registration is also mandatory, it is a separate legal entity, it has perpetual succession, and it is capable of being sued, or it is capable of suing some other person. But the definition specifically tells that cooperative societies are specifically excluded from the definition. What is the excluded? Cooperative societies are excluded from the definition of body corporate. So now, as per the conditions, is cooperative society a body corporate? Yes, because it has all the conditions, it satisfies all the conditions. But as per the definition, cooperative society is not a body corporate. Is that clear? Okay, so now where were we? Yeah, so we were discussing about corporate law. So corporate law is a law which is applicable to all types of body corporate, and as per the definition, only 4 entities will be considered as what your body corporate. First one is company incorporated in India, company incorporated outside India, LLP incorporated in India, and LLP incorporated outside India. So these are the 4 body corporates. Now, as per that, now it is very clear that any law which is applicable to the companies, any law which is applicable to the companies, and any law which is applicable to what your LLP will be considered as what your corporate laws. And the law which is applicable to the companies is the Companies Act 2013. The law which is applicable to the companies is what here? The Companies Act 2013. And for LLP, the law which is applicable is LLP Act 2008. So now these together will become part of your corporate law subject. Okay, the first part is nothing but what your corporate law. So these two will become the part of your corporate law. So what we will be studying corporate law? Companies Act 2013 and LLP Act 2008. So these together will come for across 70 marks of your syllabus. So the entire paper is for how many marks? 100 marks. Out of that, 70 marks is for what your corporate law, and 30 marks is for your other law. So 70 marks means these two acts we have to study. One is Companies Act 2013, the other is what your LLP Act 2013. These two we have to study. Okay, now coming to your other laws, coming to what your other laws. The other laws is just part B, is the part B, which comes for across 30 marks. For how many marks? 30 marks. And the laws which you have to study is, first one is interpretation of statute. And the first chapter in other laws is what your interpretation of statutes. Now this is not an act or this is not a law, but this is a chapter which will help you to understand, or which will help you to understand the law. So that is this chapter. It is not a law in itself, but it is a chapter which will help you to understand the other laws or acts which are made in India. So that chapter is called as interpretation of statute. So the second law or the second chapter you will study is your General Clauses Act. General Clauses Act 1897. General Clauses Act 1897. And point number 3 that you will study is your Foreign Exchange Management Act 1999. This is a newly act which has been added in your syllabus. Previously this act, this is FEMA, was part of your, what do you call, was part of your final syllabus. Now that has been removed from final and it has been added into your CA intermediate syllabus. Okay, so these are the 3 laws, or rather 3 chapters I would say, because interpretation is not a law. So I would rather call it as 3 chapters which you would study in your other laws, that is interpretation, General Clauses Act, and FEMA, that is Foreign Exchange Management Act 1999. Right, so that would be your entire syllabus. Okay, to sum it up, I'll just write a summary for you, the entire syllabus. Paper 2, that is your paper number 2. Okay, I'll just sum it up. And okay, so paper number 2A is called as what law? Corporate law, is called as corporate law. And paper number 2B is called as other laws. Okay, now this corporate law and other laws. So in corporate law, what are the laws we will be studying? First one is the Companies, the Companies Act 2013. Second that you will study is your LLP Act 2008. So corporate law, what are the two laws you will study? Companies Act and LLP Act. And when it comes to other laws, you will study, first one is interpretation of statute. Second is General Clauses Act 1897, and third one is Foreign Exchange Management Act 1999. So this corporate law is for how many marks? 70 marks, and this other law is for 30 marks. So this is the entire breakup of your syllabus. Okay, I hope this much is clear. Okay, now this is your entire syllabus, which I hope everything is clear till now. Okay, now moving forward, as I told you before starting the subject, I would start with the basics of law. I would start with something called as basics of law. Means, because as I already told you, a lot of people are studying law for the first time. So for them it is important to understand the basics first, and then we'll start with your actual syllabus. Okay, fine. So now, since you are studying the subject of law, first let us understand what do you mean by law. So law, in simple terms, everyone knows that it is nothing but rules and regulations. Law is nothing but what your rules and regulations, that everyone knows. It is very simple. Okay, but one more point which is important for any rules and regulations to be called as law is any rules and regulations which are imposed by government. Which are imposed by what your government. Only those rules and regulations will be called as law. Now, for example, if you are studying in a college, or if you are working in an office, let's take an example. You are studying in a college. Now, as a college, there are certain rules and regulations you have to follow. Certain rules for students, some rules for the staff as well, right? So now those are also rules and regulations, but are they considered as law? The answer is clear, no. But that is why the definition of law, when we say law is nothing but rules and regulation, it is a partial right answer. It is partially right, but for the rules and regulations to become as law, what is the second important condition is that those rules and regulations must be imposed by government. One simple example I'll give you, which will help you understand. Okay, now let's say when you're riding a bike or driving a car on the road, right? So you follow certain rules and regulations, right? When you're riding, right? What are the rules? You'll follow the traffic rules, the traffic signals. You'll follow the rule of wearing an helmet, wearing a seat belt, all of those rules, right? But these rules and regulations are imposed by whom? By the government. So now these traffic rules will become law. Why? Because first of all, it is rules and regulations, and second, it is imposed by whom? By the government. So that is why we have a separate act called as Motor Vehicles Act. Motor Vehicles Act. Okay, so now this is a law. Why it is a law? Because first of all, there are certain rules and regulations, and second is those are imposed by whom? By the government. So then it will become a law. So the definition of law is very simple. Any set of rules and regulations which are imposed by government, those rules and regulations are called as law. And if again in that law there are different types of law. Just now we discussed, one is your corporate law. So any law means any rules and regulations which are imposed by the government, only relating to the corporates, only relating to what? Your corporates, like your Companies Act, LLP Act, that is called as corporate law. Again in law there are different types of law. One is your corporate law, the criminal law, civil law, different types of law. But in basically law means rules and regulations which are imposed by the government. Was that clear to you? And in that law also, what are we studying? We are studying corporate law and other laws. Okay, so that is the definition of law. So not definition, rather I would say meaning of law, that is rules and regulations imposed by the government. That is the meaning of law. Okay. Next, moving on. Next thing is you have to understand is who has the authority. Who has the authority? Who has the authority to make laws in India? Who has the authority to make laws in India? So if you want to make any law, any kind of law, then who will have that authority, or who will make those laws, right? So now this authority of making law, that authority has been given in Indian Constitution. It is given where? Indian Constitution. Okay, according to Article 246. Article 245, article number 245 gives the authority of making laws to the Parliament. So who will make the laws in India? Parliament will make the laws in India. In simple terms, if you want to understand, Parliament is nothing but what? The government. It may be central government, or it may be what? Your state government. Okay, if it is a central government, we call it as Parliament. If it is a state government, we call it as state legislature. State legislature. And if it is central government, we call it as a Parliament. In simple ones, if you want to understand. Okay, so now who has the authority to make laws in India? That power has been given to whom? To the Parliament. According to which article? Article 245 of Indian Constitution. That power has been given, or that rather authority is given to whom? To the Parliament. Okay, so that we understood right now. So who will make the laws in India? Parliament will make the laws in India. Okay, now this article 246, there's one more article called as article 246. Now in article 246 they have given three lists. Okay, one is your union list, second is your state list, and third one is your concurrent list. Okay, article 246 gives the three kinds of list. One is your union list, second is the state list, and third one is what? Your concurrent list. Now union list, it contains all those matters for which only Parliament can make laws. It contains all those subject matters for which who will make the laws? Parliament will make the laws. For your understanding, I will just say central government. Okay, so union list contains all those subject matters on which who has the authority to make laws? Parliament, that is your central government, has the right to make the laws, and such law which is made by the Parliament will be applicable to whole of India, to every state in India. That act will be applicable if it is comes under what list? Union list. Now the second list is what? Your state list. So when what are the in state list, it contains all those subject matters on which state legislature will make laws. Who will make the laws? State legislature. And in simple words, if I have to say, state government. In simple words, if I have to say, I would rather say it was state government will make the laws, and any laws which are made by state legislature will be applicable to only that particular state. For example, if we talk about Karnataka, now if the Karnataka state legislature has made some law, that law will be only applicable to which state? Our state, Karnataka. For example, Karnataka excise law, excise duty law. Now this Karnataka excise duty will be applicable to only which state? Karnataka. Why? Because that law has been made by state legislature. Basically all this, your alcohol, tobacco, education related, what are these are the few few subject matters where who makes the law? Only state legislature makes the law. What are the things I told you? One is your related to what? Your alcohol, second is related to what? Your tobacco, third one you can say is related to what? Your education, right? These are the few areas or subject matters. Who has the authority to make law? Only state legislature has the authority to make law, and that law which is passed is only applicable to that particular state, but not every other state. So that is your state list. And third one is your concurrent list. Third one is what your concurrent list. It contains those subject matter for which both Parliament plus state legislature together will make laws. It contains those matters or those subject matters for which both central government as well as the state government will sit together, discuss and make laws. Those laws are given under which list? Concurrent list. Okay, understood? Right. So these are the three lists which is given under article 246: union list, state list and concurrent list. Union list contains all those subject matters for which who will make the laws? Parliament, and the laws which are made are applicable to entire India. Third one is state list, which who has the power to make laws? State legislature, and that law is applicable only to that particular state. And I give you example: alcohol, tobacco, education. Moving, last one is your concurrent, where both central government and state government together will make laws. Is this clear to you? Fine. Now this is what we have understood. Now second part, what is the concept you are studying? Who has the authority to make laws? So who has the authority? Parliament, and that authority is given by whom? Indian Constitution under article 245, and article 246 talks about the different list under which they have divided the powers. Like for Parliament they have given certain powers, for state they have given certain powers, and that power has been divided under article 246. I hope this is clear till now. So what till now, let us see what have we studied till now. First we understood what is law. First we understood what do you mean by law. Is this clear? Second thing, we understood that who has the authority to make law, right? Now third thing important which you have to understand is management structure in India. Third thing that you have to understand which is important is the management structure in India, right? What is the management means? How the entire nation is managed. Okay, so to manage the entire nation, the management is divided into three bodies. The management is divided into what? Your three bodies. The first body is called as legislative body. The first body is called as legislative body. Legislative body. Second is called as executive body. Executive body, and last one is your judicial body. Judicial body. These are the three bodies which manage the entire nation. Okay, first one is legislative, executive and judicial. Now when we talk about the legislative body means this body which we are talking, legislative body, the function of this body is to make laws. What is the function of this legislative body? Is to make laws. And when I say legislative body means it includes two things. One is your parliament. One is what? Your parliament, and the other is what? Your state legislature. One is your parliament, other is what? Your state legislature. So the legislative body includes two things. One is parliament and one is your state legislature. And what is the function of this body? To make laws in India. It may be any laws you have to make. If that law is regarding your particular state, if the law is relating to your tobacco, that law will be made by state legislature. If that law comes under your union list, that law will be made by parliament. Depending on what list it comes under, the law will be made accordingly. That much you understand, right? So what is the basic duty or the function of the legislative body? To make laws in the country. Second, now the legislative body has made the laws. Now, so whatever the laws you made, you have to implement those laws, right? So just making is not sufficient. You have to execute that. Execute the laws or implement the laws. So that is done by whom? Executive body. So who will implement the laws? executive body will implement the laws. Now let's say parliament has made some kind of law. Now that is the function of legislative body. Once that the function ends right there, now legislative body will make the laws, then it will be taken over by which body? Executive body, which will now implement the laws. Now this implementation or execution of law is done by the central government or state government, depending on what kind of law you are making. Okay, now in simple, if I have to say, it will be done by your ruling party, and in that also we have certain different ministries. We have different ministries. The relevant ministry will implement the law. For simple example, if I have to take, now if you want to make a law relating to your company, so what if you want to make any law relating to the company, now if that law has been made by which body? Legislative body. Now you have to implement that law. So that law will be implemented by what? Central government. So central government personally will not implement the law. They will have different ministries for each department. So if you talk about Ministry of Defense, Ministry of Education, Ministry of Finance, Ministry of Commerce, Ministry of Sports, all types of ministries you have. So depending on what kind of law you are making, so that concerned ministry will implement the law. For example, if I have to talk regarding our subject, that is company law, that is Companies Act 2013. So the concerned ministry for that is MCA, that is Ministry of Corporate Affairs. So now if the central parliament has made the law, now that will be implemented by whom? Ministry, that is Ministry of Corporate Affairs, right? And the current Minister of Corporate Affairs is our Nirmala Sita Raman. Okay, so she is what? The Minister of Corporate Affairs as well as Ministry of Finance. She is both Minister of Corporate Affairs as well as Minister of Finance. Okay, so legislative body, what they will do? They will make the laws, and that laws will be implemented by the executive body. Executive body is nothing but the ministries in the ruling party. It may be any concerned ministry. It may be Ministry of Corporate Affairs, Ministry of Finance, Ministry of Defense, Ministry of Education, and so on and so forth. Okay, right. Now two bodies are done. One is your legislative body, second is your executive body. Now third, you've made the law, second, you have implemented the law also. Now the time comes where you have to ensure the compliance of the law. Now let's say you've made a Companies Act 2013. Who has made that? Legislative body. Now that has been implemented by Minister of Corporate Affairs. Now someone should be there to even check that whether it has been actually complied means whether it has been actually followed or not. That will be done by judicial body. Means let's say there is one company A Limited, so and that Companies Act is applicable to that company, right? Now the laws are made by legislative body, implemented by executive body, but there should be someone who would monitor that or who would ensure that the laws which are applicable to them, are they being actually complied, are they being actually followed or not. That function is given to what body? Judicial body. And what is included in your judicial body? Your Supreme Court, High Court, District Court, subordinate courts, and all different types of courts comes under what body? Judicial body. So what is their function? To ensure the compliance of the laws which are made by legislative body and which are implemented by executive body. So that will be ensured, the compliance will be ensured by what body? Judicial body. So these are the three bodies under your management structure. One is your legislative body, executive and judicial body. Is this clear? And one more important function of the judicial body is interpretation. What is one more important function of judicial body? Is interpretation. Interpretation is nothing but understanding the meaning of the law. Means let's say if there is any confusion regarding the meaning of a particular word, so there is an ambiguity, so as to which meaning has to be taken, in that case the judicial body will decide what meaning has to be taken. Okay, so that is called as process of interpretation. Don't worry, there is a separate dedicated chapter on this interpretation which I will be discussing in your other law. You remember in other laws I told you there are three laws. First one is what your interpretation of statute, right? So in that chapter I will in detail discuss what do you mean by interpretation, how that interpretation is done, what are the rules of interpretation, and all those things will be discussed in that chapter in detail. Okay, so as of now just understand two functions of judicial body is, one is compliant, to ensure the compliance, and second one is to help in the interpretation of the law. So these are the three bodies and the functions of those three bodies. I hope this much is clear. Okay, so now quick recap what have we studied till now. First we studied what do you mean by law, then who has the authority to make law, and third point is we studied is management structure. What did we study? Management structure, legislative body, executive body, and judicial body. Okay, right. This much we have understood, right? Now the fourth and next important thing that you need to understand is the process of making an act, or law. What is the process, how an act comes into existence, that we will understand today. Okay, right. Now we'll take an example. Let's assume for a while that there is no Companies Act as of now. So we want to bring new Companies Act, we want to bring a new act called as the Companies Act 2023. We are just assuming that there is no Companies Act as of now, so we want to bring a new act called as Companies Act 2023. So now if you want to bring any new act, what is the process, how do you make a new act? That is what we are going to study now. Okay, fine. Now the first thing is, first you need to understand the need for such law. First you have to see why there is a need for making such law. First you have to see, is there any need? Okay, so if there is any need, then you have to tell what is the need for having such law. Okay, now second, once you find out the need, then the first thing is that need will be understood by the concerned ministry, and I told you the concerned ministry for company law is what? Your Ministry of Corporate Affairs. So the Ministry of Corporate Affairs first will ascertain or determine what is the need of this Companies Act 2013. So once they understand or determine what is the need of this Companies Act 2013, the Ministry of Corporate Affairs will set up a committee. And this committee will consist of different people who are experts in that particular field. So if you are talking about Companies Act 2013, so every person who is expert in that particular field will be the part of the committee, and that committee will be headed by a person called as the chairman, right? Now the committee which was set up for Companies Act 2013 was called as J.J. Irani Committee. What committee? J.J. Irani Committee, means the person who was heading that committee or the chairman of that committee was called, the person called was J.J. Irani. So that hence the name is what? J.J. Irani Committee. So now MCA wanted to make the Companies Act 2013 or 23. So they first set up a committee. So that committee, what was the name of that committee? J.J. Irani Committee. Okay, fine. Now these people who are experts in the field of that experts in that particular field, they will give their recommendations. They will give their recommendations as to how the law should be or how the act should be. So they will give you a blueprint. Okay, these are the things you have to include in the act, these are the things you should not include in that. All this basic, they will prepare a kind of draft. So they will tell, okay, how the act should be there, all that will be explained, and those are called as recommendations. Okay, so those recommendations will be given by whom? By the committee. Those recommendations will be forwarded to the ministry, concerned ministry, that is your Ministry of Corporate Affairs. Okay, now once these recommendations are given to Ministry of Corporate Affairs, those recommendations will be forwarded to the related professional bodies. Now related professional bodies means any professional body which is concerned with the law which you are making. Now if you are making what act? Companies Act 2013. So you have to see what are the professional bodies which are concerned or which are affected by this law. For example, what are the professional bodies relating to Companies Act 2013? Or if I have to ask, or if I have to say, which are the professions which study company law? Simple, like who studies? CA people, CA students study company law, CMA people study company law, CS company people study company law, right? So these are the professions which study the company side, and the body which is regulating them is called as professional body. So when it comes to CA, what is the professional body? ICAI. For CS it is what your ICSI, and for CMA it is what your ICMAI, right? So these are what your professional bodies which are concerned with the act which you are bringing. So when you are, if you want to bring Companies Act, what are the professional bodies? ICAI, ICS and ICMA, right? So now the recommendations which were given by the committee, that will be forwarded to whom? To the professional bodies. Now these professional bodies will give their suggestions, will give their what your suggestions as to what are the additions, what are the recommendations are already made by the committee. So they will also give their own personal suggestions, since they are also somewhat expert in the field of law. So if I am like for example, now I am a chartered accountant, so I also will have certain knowledge regarding Companies Act 2013. So I would also give my inputs, give my suggestions, and that suggestion will be taken into consideration by the committee as well as the ministry. Okay, that right you have as a member of the professional body. Okay, right. So now once the recommendations are made by committee, and second, first what is done, recommendations will be made by the committee, second is suggestion will be given by the professional bodies. So that suggestions will be again forwarded to whom? To the MCA. Now MCA, along with the recommendations which they already have, suggestions given by the professional body, and they will add their own inputs. Recommendations given by whom? By the committee. Then suggestions given by the professional bodies, and adding their own inputs, they will prepare one draft. They will prepare what? A draft. That draft, in legal language we call it as bill. That draft which is prepared by the ministry, which is based on the recommendations given by the committee, suggestions given by the professional bodies, and adding their own inputs, they will prepare a draft. A combination of all this, they will prepare a draft, and that draft in legal language we call it as what? Bill. Now that bill will be presented in the parliament. That bill will be presented where? In the parliament. And we all know that in parliament there are two houses, one is your Lok Sabha and other is what? Your Rajya Sabha. Okay, so first the bill will be passed where? In the presented where? In the Lok Sabha. Let's say there are on an average 550 members in the Lok Sabha, on an average 500 to 550 members in what? Your Lok Sabha. So first, the majority of the people in the Lok Sabha. So when do we say it's a majority? When more than 50% of the people give their approval, then we will say that bill has been passed in the parliament, where majority of the people give their approval. Then we will say bill has been passed where? In the Lok Sabha. If the bill has been passed in Lok Sabha, then we'll move towards where? Rajya Sabha, right? Again in Rajya Sabha, let's say on an average there are 250 members. So if 126 people give their approval, then we will say the bill has passed in where? Rajya Sabha. So first the bill has to be passed in Lok Sabha, then the bill has to be passed where? In the Rajya Sabha. Once the bill has been passed in both the houses, then it will be forwarded to our honorable president. Honorable what? Your President of India. So that president will now have to give his approval. So once the approval is taken from whom? Lok Sabha and Rajya Sabha, then president will have to give his approval. That we call it as assent. Assent means nothing but to give the approval. So once the approval is given by Mr. President, then the date on which the President has been given, assent has been given by the President, that day is called as enactment date. That day is called as what? Your enactment date. Okay. So when it comes to Companies Act 2013, 29th August 29th August is the enactment date. Means what does this enactment date signify? It signifies that on that particular date, Mr. President gave his approval for that law or for that bill, and from that day the bill will become act. So now previously it will be called as Companies Bill 2013. Now it is called as Companies Act 2013. Are you understanding? Right. So that is how this entire process is followed for making any act in India. It may be any act, any kind of act. So that is the procedure. What is the procedure? First one is you have to set up a committee. Committee will give the recommendations. Professional body will give their suggestions. Then along with their inputs, they will make a bill. That bill will be passed where in the Parliament, in Lok Sabha, Rajya Sabha. Then you have to take the approval of what? Your President. And the date when you get the approval of President is called as what date? Enactment date. And what is the enactment date for our Companies Act 2013? 29th August 2013. Okay, right. But there is one more date called as commencement date. There is also something called as commencement date. What is enactment date? I told you, the day when you get the approval of the President. That date is called as enactment date. Commencement date is the date from which the law actually becomes applicable. The date from when the law actually becomes applicable. For example, now let's say in our colleges there's one rule saying that from tomorrow, let's say in an office, the rule has been made that saying that from, let's say the date, today date is, what is the date? 9th of, what is the date today? It is 9th of January, right? What is the date? 9th of January, today's date. Now the office makes a rule saying that from 15th January everyone has to come in formals. That is the rule which has been made. When is the rule made? 9th January. But when the rule starts to be applicable? 15th January. So 9th January will be called as enactment date and 15th January will be called as commencement date. So similarly, when the President gives his assent, that date is called as enactment date. But the day from when the law will be actually applicable, that date is called as commencement date. And the commencement date for companies is 12th September 2013. What is the date of commencement date? Means from when actually the law was applicable? 12th September 2013. But when was the approval taken? 29th August. So from 29th August to 12th September, even the law was made, but it was not applicable. Are you understanding? The day when it becomes applicable is called as commencement date, and the date you get the approval is called as enactment date. So these are the two different dates you have to understand. Okay, now this is the entire procedure for making the law. I hope you have understood loud and clear. Okay, fine. Now next thing you have to understand is, the next topic is your sources of law. This is very important topic, sources of law, right? Okay, there are, you can also call it as types of law also. You can also write this as what your types of law, or you can also call it as sources of law. Okay, the first source or the first type of law is called as act. The first source or the first type of law is called as what? An act. Now what do you mean by act? Act is a type of law, it is a type of law which is enacted or which is passed in the parliament. Any type of law which is passed in the parliament, such laws are called as act. Example is your Companies Act 2013. Why it is called an act? Because it is enacted or it is passed in the parliament, and by following the procedure which I have just explained you, right? What is the procedure? Setting up a committee, taking the approval of parliament, taking the approval of president, right? All this procedure if you follow and if you pass any act in a parliament, such law is called as act. I give an example: Companies Act 2013, LLP Act 2008. All these are what are types of law which are passed in the parliament. Is this clear to you? Fine. Now second type of law is your rules. Okay, now please focus, this is a bit technical, so focus what I am trying to say now. Okay, the first type of law is what? Your act. That is very simple. Any law which is passed where? In the parliament, by taking the approval of Lok Sabha, Rajya Sabha, and taking the approval of president. That is called as act. Now second type of law which you have is your rules. Okay, now everybody please focus, a bit technical it is, you have to understand. Okay, now whenever you study any act, it may be, let's say, take an example of the Companies Act 2013. Companies Act 2013. Okay, so if you are studying any act, it may be any act. For instance, let us take an example of Companies Act 2013. Whenever you study any act, act cannot be studied in isolation. Act cannot be studied very in isolation. If you want to actually understand the entire act, you have to read it along with the rules. You have to read it along with what? Your rules. You have to read it along with the schedules, right? So now, because there are certain things which are not given in the act, but they are part of what? Your rules. Okay, now what is the difference between act and rules is, act, I told you, is passed where? In the parliament. And when I say it is passed in the parliament, means it is passed by taking the approval of Lok Sabha, taking the approval of Rajya Sabha, and taking the approval of what? Your president. But when it comes to rules, it is a type of law, it is a type of law which is passed by the central government, or you can also say ruling party, and again in detail if I have to say, the concerned ministry. It is a type of law which is not passed in the parliament, but it is passed by whom? By the ruling party, or you can say the concerned ministry. So if I have to talk about the Companies Act 2013, what is the concerned ministry? I told you, MCA. Now if you want to make Companies Act 2013, that will be made by the parliament. But if I have to say companies rules, that will be made by whom? By the MCA, and in that case you don't have to take the approval of parliament. That alone can be done by the concerned ministry. Okay, now so why this differentiation is, whenever I talk about rules, no, this rules contains those provisions, rules contains those provisions which are prone to frequent changes, which are prone to what? Your frequent changes. Just a second. Rules generally are used for those provisions which require frequent changes, or which are your monetary provisions, which contains what provisions? Monetary provisions means where amount or money is involved. Such laws are not given in act most of the time. Those are given where? In the rules. Or second types of provision which are your procedural provisions. Wherever they have to mention the procedure. Okay, for example, if they have to mention what is the procedure to incorporate a company, so such kind of procedures most probably they won't be given in the act, they will be given where in the rules. Now the reason, now you understood what is given in the rules, now you have to understand the logic behind why it is not part of the act and why it is the part of rules. That is the most important thing that you have to understand. Okay, now everybody focus. Coming back to your act, what did I say? Act is a law which is passed where in the parliament. That much is clear, I hope, right? And when I say it is an act which is passed in the parliament, means you have to take the approval of Lok Sabha, you have to take the approval of Rajya Sabha, and you have to take the approval of what, your president. Then it becomes what, an act. Now, but if you want to make rules, no, then you don't have to take the approval of Lok Sabha, you don't have to take the approval of what, your Rajya Sabha. But who can directly make such rules? The concerned ministry, and the Ministry for Companies Act is what, your MCA. Now why this has been made is, now understand one point. Let's say you have made a Companies Act 2013. Okay, Companies Act 2013 has been made. Okay, let's say, and there are total 470 sections. How many sections in total we have? 470 sections which are in the Companies Act 2013. Now let's say tomorrow you want to make certain changes in Companies Act 2013. We want to make certain changes, and those changes we call it as amendments. We call it as what, your amendments in our legal language. Okay, so if you want to change any part or any provision of the law, that change is called as what, your amendments. And the law says that whenever you want to make any amendments, it is as good as making a new act. What does it say? If you are making, even if the change is the slightest of change, even if the change is the very slight change, it will be considered as you are making, as if you are making a new act. Now what does it mean? It will be considered as if you are making a new act means, again you have to follow the procedure. What procedure? Taking the approval of Lok Sabha, taking the approval of Rajya Sabha, taking the approval of what, your president. So then only you can make the amendments. That is what the procedure is. If you want to make amendments, it will be considered as if you are making a new act. And when I say as if you are making a new act means, it implies that you have to again take the permission of Lok Sabha, take the approval of Rajya Sabha, take the approval of president. Only then you can make the changes. So now if there is a certain provision which is part of act, now if you want to change, it becomes a very hectic procedure. Okay, so what the lawmakers do is, so that is why I told you, any provision which requires what, frequent changes, or if it involves what, monetary provisions, or if it is something which is procedural, these are the two things which most probably required to be changed from time to time. Now if you want to change from time to time means it is called as amendment, and whenever you are making an amendment, again you have to take the approval of Lok Sabha and Rajya Sabha. So to avoid that hectic procedure, what they do is, lawmakers, any provisions which is related to your monetary provisions, or in short any provisions which require what, frequent changes, that will not be part of your act, that will be part of what, your rules. And why is that? Because we don't have to take the approval of parliament, directly the concerned ministry can make the changes. Okay, for example, I'll give you now, let's say Indian Contract Act. When is the Indian Contract Act made? In the year 1872, right? Now in 18, let's for example, let's say in Indian Contract Act they have given a fine, let's say ₹10. If any person violates the law, let's say there's no such law, but I'm just giving you for an example. Let's say in Indian Contract Act 1872 there is one law provision saying that if you violate the law, you have to pay penalty of ₹10. Now you tell me the value of ₹10 in the year 1872 and today in the year 2024, is it the same? Obviously no, the time value of money keeps changing. So the value of ₹10, let's say it will be approximately is equal to what, your 10,000 of today, right? Now if you put someone a fine of ₹10, do you think they will do you think people will follow the provisions or rules? No. So now from 10 you have to bring it to what, your 10,000. So if you're changing means nothing but it is what, an amendment. And if you're doing amendment means again you have to take the approval of Lok Sabha and Rajya Sabha. So that is why what happens is most of the time this monetary provisions what you study or which you have will not be part of your act but will be part of what, your rules. And the logic is simple because they require frequent changes, and if you do every time, if you want to change, you don't have to take the approval of parliament. Directly the central government can do it on its own. Is this clear now? So that is what rules. So what do you mean by rules? It is a type of law which is passed by the ruling party or which is passed by the concerned ministry without the approval of parliament. I hope this is clear to you, because this is a very technical part, and this part, rules, is very important to understand the Companies Act which we are going to study later. Okay, whenever that point comes again I'll come back to that point. Okay, but make sure you understand this point, because this is a very technical point, and being a chartered accountant student you have to understand these logics. Just mugging up the provision is not sufficient, because as and when you go from intermediate to final, the level of questions, the technicality and the analytical part increases. So for that particular reason you should know what are the basic things, all these things which will help you to understand the law much better. Okay, so we were studying what types or sources of law, and what is the first source of law is, that is your act. What is act? It is a type of law which is passed in the parliament. Second is what, your rules, any type of law which is not passed by the parliament but it is passed by the ruling party without the approval of what, your parliament. Generally what is included in rules? Any provisions which require frequent changes, or which are what, your monetary provisions or certain procedural provisions. All those are given in the rules. Is this clear? I had told you the logic behind that. Okay, fine. So that is your second type of law. Third type of law is your case laws. Third type of law is what, your case laws. Now case law means what? It is also a type of law. It is also a type of law which is based on the decisions or the judgments given by the court. It is a type of law which is based on the decisions or the judgments, previous decisions or the judgments given by the court. Such law is called as case law. Now what do you mean by this case law in simple terms is, now I'll give an example. Okay, now whatever I told you just now, first types of law, one is act and second is rules. These are the actual written form of laws. These are documented written form of laws. But when it comes to case law, no, it is not a written or documented form of law, because what happens is, I'll give an example. Now let's say case law means, I told you it is a type of law which is based on what, your decisions or judgments given by the court. Example I'll give. Okay, everyone is aware of this Nirbhaya rape case, right, which happened in the year 2012, right? Now before 2012 there was one law relating to the minors. Minor is nothing but any person who is below the age of 18. Any person who is below the age of 18 is called as minor, and if that minor commits any offense, that person is called as juvenile. First of all, understand what is minor. Any person who is below the age of 18 is called as minor, and if that minor commits an offense, that person is called as juvenile. Now juvenile and minor are not the same, the age is same, but if you are normally any person below the age of 18 is called as minor. But if let's say the minor is committing a criminal offense and if he is below the age of 18, then he is not just called as a minor, he is called as a juvenile. And the person who is committing the crime, and if he is a minor, is called a juvenile, then the punishment for that person will be different from the punishment of an adult. Let's say there are two people, Mr. A and Mr. B. There are two people, Mr. A and Mr. B. Okay. Now Mr. A is age of 17 and Mr. B is age of 25. What is the age of Mr. A? 17 and age of Mr. B is 25. Both the people have committed same offense. Let's say offense of what? Your murder. Same offense committed by A also, same offense committed by B also. But there is an act called as Juvenile Justice Act. Juvenile Justice Act. Now, according to the Juvenile Justice Act, it says that whatever the punishment you give to a normal adult, the same punishment will not be applicable to this juvenile. There are certain exceptions or exemptions given to the juvenile just because he is below the age of 18. So that is given under Juvenile Justice Act. Okay. Now the law says what? If you are below the age of 18 and if you commit a crime, you are called as a juvenile, and the punishment for the juvenile as less strict as compared to the adult. And the logic is simple, because you are not an adult. But in this case of Nirbhaya case, what happened is, total 6 people were the people who committed the offense. Total how many people? 6 people have committed the offense, out of which one of them was minor. Out of one of them was what? A minor. Okay. And his age was 16. What was his age? 16. So now what happens is, rest other 5 people were what? Adults. Rest other 5 people were what? Adults. So now according to the adult Indian Penal Code, all these people were hanged to death. All these 5 people were what? Hanged to death. And because the Juvenile Justice Act does not give you permission for a minor to hang, the punishment for that person who was below the age of 18, the punishment was less strict, means he was not hanged to death. But what did the court say? This is the law. What is that law? If you are a minor and if you have committed a rape, in that case you cannot be hanged to death. That is the law. But what happened in this case is, the crime which was committed, the judgment said that it is an heinous crime and it is a case of the rarest of rare. Now just focus on the language that they are using. The judge said that the crime which is committed by the minor comes under heinous crime, means the crime is so much brutal that it made the judge to look behind the age of the person. Heinous crime means the brutality of the crime was such that the judge had to look beyond the age of the person. So he said that the age will not be a relevant factor because the crime was such brutal that the age will not be the deciding factor, because the level of the brutality, the crime was such brutal that now I will not look at the age of the person. I would rather consider that minor as what? An adult, because this is a rarest of rare case. It is not only rare, it is the rarest of what? A rare case, which made the judge to think that, and the judge said that even if this person is what? A minor, because looking at the kind of the offense or the kind of crime, since it is a heinous crime and it is a rarest of rare case, the judge said that he should be treated as an adult and accordingly he should be given the punishment. Okay. But that is not allowed according to which act? Juvenile Justice Act. So because of which now that person is not hanged to death and is free from the punishment. So now all this I explained you why, because now what happened is, because of this case, what happened is the court gave a judgment saying that from now on, what was the definition of minor? I told you 18, right? What was the definition of minor? I told you 18. Now, so that definition of minor, now they have said that now it will be reduced to what? Your 16. Now that will be reduced to what? Your 16, means even if you are age of 17, then you will be treated as what? An adult, and accordingly the punishment will be given. Now this is not written in Act, but now this is because of the particular case. Now from now on this law will be followed. So any law which is based on the judgments given by the by the court, that laws are called as case laws. These are not written somewhere, because these are the judgments which which are not provided in the what do you call in the act, but these are very peculiar cases which are something which no one would thought of would happen something like that, because no one would think that a person who is of age of 16 would commit such heinous crime. The lawmakers, when the law was being made, what was the intention and what was the assumption of the lawmaker, saying that if you are below the age of 18 you would be still an innocent person, you would never even think of committing such crime. That was the intention behind making such law. Now, but this is the rarest of rare case where even a person who is age of 16, who is below the age of 18, still has committed a crime which otherwise would have not been committed by a minor. Now this is a very rarest of rare case. Now so accordingly, so the law has been changed, saying that even if you are below the age of 18 we will consider as what, an adult. This is nowhere written, but this is only purely related to that particular case. Now in future, tomorrow, if some other minor commits any rape, in that case this law will be referred. Now whenever you give a reference of previous case, that is called as case law. Now let's say in tomorrow's, let's say one person, again minor, who is age of 17, if he commits a crime, then again he cannot be taking a defense saying that I am a minor and I should not be hanged to death. Now why? Because it is already been decided that in the case saying that even if you are minor you will be treated as an adult. Why? Looking at the seriousness and the brutality of the crime. But important thing you have to remember is this law is not applicable as it is. Means what happened is, you have to look at the facts and circumstances of each case. You cannot directly apply this case to other cases. First you have to see what are the circumstances, what are the facts of the case, then the judge will decide whether this case law is applicable to this or no. So now the judge has an discretion. Now let's say tomorrow one minor commits a crime and commits a crime of rape, and if the judge feels that the crime or the rape which was committed, if it is not that heinous and if it is not that brutal, in that case there is no the judge may decide not to treat him as an adult. So whenever it comes to all other laws, no, act and rules, it is a compulsory law you have to follow. But when it comes to case law, no, it is completely at the discretion of the judge. It is nowhere written that you have to compulsorily follow this law, because it is a law which is given for particular cases. It will not fit as it is for every case. Depending on the facts and circumstances, you have to modify and then give the judgment, right? So that is why we will not consider this case laws as a written or documented form of law, but it is used as a reference for future cases which come. So if your case is similar, then the court might, if the judge feels that if it is similar, then he can give the reference of this case and he can give the punishment accordingly. Okay, so first two laws which I told you are documented and written form of laws, and which have to be mandatorily followed by every person. Okay, and if we do not follow, there will be legal consequences. But when it comes to case law, no, it is not a documented form. It is that entirely at the discretion of the judge whether to apply this case or no to that particular case. Are you understanding what I'm trying to say? Yes. So for what are the first three types of law? First one is act, second one is what? Rules, and third one is what? Your case law. And what do you mean by case law? Any law which is based on the judgments given by the court. Such laws are called as case laws. Okay. Okay, fine. Now, moving on to your fourth type of law. Moving on to the fourth type of law is your ordinance. Fourth type of law is what? Your ordinance. Now, ordinance means what? It is a temporary law. It is a type of law, but what kind of law? Temporary law which is passed by president. Now focus. Normally I told you, if you want to make any law, the law will be passed by whom? By the parliament. But if there is any particular law, and if that law is a temporary law, and if it is passed by whom? By the president. But why is it passed by the president? Because the parliament is when the parliament is not in session. Again, what do you mean by ordinance? It is a temporary law which is passed by the president, and when it is passed, when the parliament is not in session. Now what does this mean? Now whenever you say parliament, no, the parliament will not be functioning 365 days. It will not be functioning all the 365 days in a year. Obviously there will be certain breaks, just like you have your summer vacations, whatever, this Christmas vacation. So similarly, every 2-3 months the parliament will not be in function. So that is called, we say that parliament is not in session. Okay, now let's say in the month of June, for 30 days the parliament is not in session, means the parliament is not functioning. Now let's say for this 30 days, in between these 30 days you have to bring an emergency law. You have to bring a law which is what? An emergency need to bring that law. Now I told you, normally if you want to bring any law, you have to pass it in where? In the parliament. Now if the parliament is only not in session, then how can you bring the law? And I told you that the need of this law is very, very urgent. So now what happens in that case is, the constitution has given the power to whom? To the president. So now what is the normal procedure? First you go to the parliament, Lok Sabha, Rajya Sabha approval, and then you will go to the president. But now since the parliament is not in function or not in session, and there is a urgent need of the law, so in that case what they have given an exception, saying that instead of going to the parliament, since the parliament is not in function, you can directly, who can give the approval? President will give the approval, and that will become the act. But it says, and I told you why is it temporary law, because once the parliament comes back in session, once the parliament is back in session, within next 6 weeks you have to take the approval of what? Your parliament. Now for time being, who has given the permission? President has given the permission for time being, because the need was urgent. But once the parliament is back in session, obviously eventually the parliament will be back in session, may it be after 20 days, 30 days, but eventually the parliament will be back in session. Whenever the parliament is back in session, within 6 weeks you have to follow the normal procedure. Normal procedure is nothing but you have to take the approval of parliament, you have to take the approval of Lok Sabha, Rajya Sabha, then approval of what? Your president. If you can do so, and if you take the approval of parliament, then this temporary law will become permanent. This temporary law will become permanent. If you cannot take let's say the parliament, the Lok Sabha people did not give you the approval, in that case this temporary law will be cancelled. We say that law will be repealed, means the law will no longer be applicable, it will be cancelled. That is why it is temporary law, because there is a question whether tomorrow it will become act or it will not become act. That is completely depend on the approval given by the parliament. If the approval gives if the parliament gives the approval, it will become permanent act, and if the approval is not given by the parliament, then act will be repealed. So simple. Again, ordinance means what? Any law which is what? Temporary law which is passed by the president when the parliament is not in session, and once the parliament is back in session, within 6 weeks you have to take the approval of parliament. If you do so, it will become permanent act. If not, the act will be repealed. Is this clear? Such law is called as ordinance. Is this clear? Okay, fine. Third type of law is your code. The third type of law is what? Your code. Now what do you mean by code? Code is nothing but it is the consolidation of existing acts. Consolidation or combination of all existing acts. Okay, I'll give an example, then you will understand better. Okay, right. What do you mean by code? It is a type of law which is consolidation or combination of all existing acts. Now what example is, now let's say there is one code called as insolvency and bankruptcy code 2016. So now what is the word here? Code. It is also type of law, but what is the difference here? You have to understand. Insolvency and bankruptcy code means what? It is consolidation and combination of all existing acts. Now before this insolvency and bankruptcy code had come, there were different acts which were dealing regarding your insolvency and which were dealing regarding the bankruptcy. Means if you are a company and if you are going into insolvency or if you are going into bankruptcy, there was a different act. If you are an individual, if you are going into insolvency and bankruptcy, there was a different act. So there were different acts, but all those acts were somewhere related to what? Insolvency and bankruptcy. There were different acts. There was Sick Industrial Act, there was Debt Recovery Act, there were different kinds of acts which all were discussing only regarding what subject? Insolvency and bankruptcy. Now the lawmakers thought that why to increase this confusion of having different acts. So any which ways all these are talking about what? Insolvency and bankruptcy only. All the provisions all in different acts are relating to what? Insolvency and bankruptcy only. So what the lawmaker did is they combined all the other acts and they made into a new law. That law will be called as code. As simple as that. Code is nothing but consolidation and combination of all existing acts, and the new law which you make is called as code. Example is in front of you, simple: Insolvency and Bankruptcy Code 2016. One more example is Indian Penal Code, IP. See, these are the few examples of what your code: Insolvency and Bankruptcy Code, Indian Penal Code 1860. Indian Penal Code 1860, Insolvency and Bankruptcy Code 2016. It is nothing but consolidation and combination of all existing acts. Is this clear? Okay. So these are the 5 types of, or 5 sources of law. Again, what are the 5 sources of law? First one is your act. Second one is what? Your rules. And third one is what? Your case laws. And fourth one is what? Ordinance. And fifth one is code, right? So these are the 5 types or 5 different sources of law that are given. Okay, I hope everything is clear till now. Okay, very good. Moving forward. Okay, now okay, right. Can you see something on the board? Okay, now this is called as section. And how do you read this is, so the first part is called as section. The first part, numerical part, is called as section, and the second part, which is given in the bracket, is called as subsection. Is called as what? Your subsection. Third part is called as clause, and the fourth part is called as subclause. Fourth part is called as what? Your subclause. And whatever the content is given in all these 4, whatever the content in given, together we call it as provisions. Together we call it as what? Provisions. Okay, first part is called as section, second part is called as subsection, third part is called as clause, and the fourth part is called as subclause. There is nothing beyond that, only 4 parts. And whatever the content is given in section, subsection, clause and subclause, together we call it as what? Your provisions. Is this clear? So this is the basic thing you should understand: section, subsection, clause and subclause. I hope this is clear to you. Okay, now, but there is one section called as section 2. There is one section called as section 2, which is called as definition section, or also called as interpretation clause. It is called as interpretation clause. Now definitions, every act you pick up in India, it may be any act, it may be Companies Act, it may be LLP Act, it may be Indian Contract Act, any act. The section 2 is specifically reserved for what? Definition. Definition is nothing but every word any word which is used in the particular act again and again, then the meaning of that word will be given under section 2 under what your definitions. Okay, right. So whenever you are studying definitions, then this rule will not be followed. What rule? Section, subsection, clause and subclause. For example, if I write this 2 and 20, if you go by normal rule, how would you read it? Section 2 subsection 20, right? But when it comes to definition section or interpretation clause, this second part which is in bracket will be called as clause, and the first part will be called as what? Your section. Because in case of section 2, there is no subsection, there is no subclause. First part is called as section and second part which is written in bracket is called as what? Your clause. So this is only for which section? Section number 2. But for every other section it is what? Section, subsection, clause and subclause. This is understood now. Why it is called as clause and why it is not called as subsection? That you have to understand logic. Simple logic now. If I write something heading, okay, this is the main part, and if I want to write something, then this is called as sub part, right? This is your main part and the sub part is given below, right? Now why do we write sub part? Because it is somewhere related to the main part. If I write say main part, okay, and then I write something again sub, so this is somewhere related to the main part, that is why we call it as sub part of it, right? So similarly, if I am writing something in this first part section, the related to that only I am writing in the second part, that is why it is called as sub section, because the first part and second part are somewhere related. But when it comes to definition, no. So if I say section 2 clause 20, so for this the definition is regarding what? Your company. Then when it comes to section 2 clause 21, it is regarding to definition of company limited by guarantee. Now this limit company and company limited by guarantee, that these two parts are not related at all. So that is why we cannot call it as subsection, we call it as different clause, because clause 20 is about company and clause 21 is talking about company limited by guarantee. Since they are not interrelated, we don't call them as subsection, we call them as what? Clause. And that is only for what section? Section number 2, that is specifically dedicated for definitions, or specifically we also call that as interpretation clause. Is this clear to you? Right. So how do you read the section? First part section, subsection, clause and subclause. And when it comes to section 2, first part is called as section and second part is called as clause. I hope this much is clear. Okay, right. One more thing now. Okay, right. So this is the name of a case law. What is the name of case law? Ashbury Railway Carriage Company versus Ritchie. Now this is a case law which we'll study in our coming chapters. Okay. Now how do you read this case law? Is the first part, Ashbury Railway Carriage Company versus Ritchie. So the first person is called as a plaintiff. The first person is called as what? A plaintiff means the person who has initiated the case or person who has filed the case. That person is called as plaintiff. And the second person is called as defendant. The second person is called as what? As a defendant, means the person against whom the case is filed or the person who is defending the case. That person is called as defendant. Let's say, I don't remember the exact year. Let's say we'll take 1876. What is the year? 1876. Now this year represents the year of judgment. It represents what? Your year of judgment. Now it does not represent year of filing the case. It represents year of the day, the year in which the judgment was given. It might have been filed 5-10 years before, but it represents what? The day when the judgment was given by the court. So the first person is called as plaintiff, means the person who has filed the case. Second person is called as defendant, means the person against whom the case has been filed, or the person who is defending the case. And the third, the year represents the year of judgment and not the year of filing the case. I hope this is clear. Okay, so these are the small things which I had to tell you, so that you will have a basic knowledge how to read a section, how to read a case law, right? So these are the small things that you have to remember. Okay, so this was everything about what your basics, right? So these are the few things that you should know before starting with the actual syllabus. I hope that is clear to you. Okay, I'll just do a quick recap whatever we studied till now. So first thing we studied is we understood what is the meaning, or what do you mean by law. We understood what is law. Second thing we studied is who has the authority to make law. Third is your, what do you call what is the process to make the law. Then we studied what is the management structure in the country. Then we studied what are the different sources of law. And last we studied how to read the section and how to read the case law. Okay, I hope everything is clear till now. Okay, so we'll stop here for a while. We'll take a 5-10 minutes break, and after that break we will start with the actual syllabus. And the first thing what we'll start with is your Companies Act 2013, that is part of your corporate law. Okay, let's take a break for 5-10 minutes and then we'll continue. Okay.